petition to the U.S. Supreme Court, do you support requiring compensation for the use of private property to comply with the CAO? Was that if the CAO takes property from you, do you think it's reasonable to be compensated for that? I guess that's kind of what they're asking.
Well, if that's the question they're asking, if you lose, that's an interesting question, because I've been in conversation with the assessor on that as well too. If you lose property to a critical area, are you going to be compensated for that property or not? Or is it going to be, you'll be compensated through your taxing? That is a huge issue that's out there right now with all the assessors. The assessors are trying to address that. So if you had 40 acres and you had 5 acres of that was in a wetland, there was no way you're going to be able to do it. Would you be compensated when it came time to tax for that? So that is a question that's out there. But if you had 40 acres and you had 3 acres that was a wetland, but it attracted wildlife, would it be a benefit to you, or would that be a hindrance to you? So those are questions that are still floating out there without an answer. One time too, we think that route.
Michael?
Well, we already have setbacks on the waterfront, and I don't think that, I think it would depend a lot on the property if you were going to, if you want to consider it takings for setbacks from critical areas or the waterfront. Right now we have a 50-foot, you know, from the top of the bank or the water. So I think it's a really hard question or really hard issue to determine what type of compensation would be allowed, since we already do have setbacks with no compensation on a lot of waterfront properties.
Bill?
Yeah, I was going to make the same point. We already have setbacks on property lines. You can't build, you know, your house right on the property line. You got to be at least, I think it's 10 feet off. So the first question is, will the Supreme Court decide that it is a taking? Right? That's for them to decide. Right? Clearly the question is, if you, as a result of the critical areas ordinance, if you now have property that is unusable, I would expect the valuation of the property to actually go down because it's unusable land. We don't pay as much for, you know, beautiful scenery as we do for working land or residential building space. So, and to answer, you know, sort of what Bob was saying with the assessor. So I think that'll actually be the result. So I'm interested in seeing what the actual Supreme Court decides on that particular suit. And we'll all just sort of have to wait and see. And then we'll figure out what we do as a result of that decision. And it's a statewide question, so it's going to be more than just San Juan County.
Okay.
So, first of all, the Supreme Court has to decide if they're going to even take the case, and that hasn't happened yet. In responding to the question in regards to the actual case itself, I don't believe in taking, I don't support a taking, but the way this is positioned, in San Juan County, the critical, if you have a house, if you have a legal parcel that the county has given, and it's 100% a wetland, the county cannot prevent you from building a house. You may not build the exact same house that you want to, exactly where you want to put it, but our position in this whole lawsuit is that it isn't a taking when you have requirements and setbacks, because we're following what the states ask us to do for critical areas. So I don't support what Caper's doing, bringing this forward, or the PCL, but PCF.
PLF.
Sorry.
Palestinian Liberation.
Yeah, anyway, so I mean, that's my, I don't think the Supreme Court is even,
I'm sorry.
I mean, it's gone through every level in the state of Washington and has not been, their argument hasn't been accepted, so it will be interesting if the Supreme Court does take it on, but I don't consider it a taking.
Can I interrupt? Is this the state Supreme Court or federal?
Federal.
This was talking about the federal one question.
U.S.
Okay, thank you.
It's
So we
US
have a
Supreme
follow-up,
Court.
Michael?
We're talking about takings. This council, in improving the Deer Harbor Bridge, they condemned property in order to make a big 20-mile-an-hour curve. There was a choice of having a stop sign or having a curve. That was federal funds. They either had a stop sign or you have a 20-mile-an-hour curve. This council decided to go for the 20-mile-an-hour curve, property, so that's, you know, that was something that I didn't approve of, the neighbors didn't approve of it, but, I consider that takings, myself and the council decided to go forward with it, so we see what the council, this council does.
You get paid for it?
They got paid for it, they didn't like it, you know, they want to have.
The
Yes.
owners get paid for it.
Yes, the owners got paid for it, so it was, they condemned the property, they paid them for it, but there was a choice of whether to condemn the property and put in a big curve, or not condemn the property and go with the existing footprint of the
So
road.
the people wanted a different solution, the county.
The locals didn't want a different solution, the locals wanted a stop sign,
Yeah, that's different than a
right.
curve.
right, and the county decided to put in the curve. So it was federal money, $3 million, I know money talks a lot, so, but that's what happened, just recently.
Can I respond to that?
Yes.
That is just so not true. That there was never a plan that said that Mr. Durland wanted to have a stop sign there, but that was never the situation. The reason it was condemned, and I'm not even sure I should go into the reason why it was condemned, but the property owner who owned the property wanted to sell to us, but we couldn't clear title, and the only way to clear title so we could take it was for us to have to condemn the process. The property owner was given a fair amount, even more than we thought we were going to get. Some of the adjacent properties may not have liked that, but the person who owned the title was given money that we went through an arbitrator to come up with a fair amount, and that's it. It wasn't a taking, it was, you know, this is where we wanted to do the bridge, the person said he wanted to sell it. We couldn't clear title, so in order for us to clear title in a responsible way, we had to go through that process, because there was a lot of liens in the property. So that was not us being rogue, that was us trying to prevent long-term protection for the county, and to do what, we went through 1.5 years of work with the Deer Harbor community coming up with a design. We went painstakingly through many iterations of how this would look, and the community voted on it. There's public records for this. I mean, so this wasn't like we're just gonna go in and take this over. It was, the community said this is what we wanted. We went through the land acquiring process. If there was a problem with the title, the only way we could do it to clear title was for us to do that.
Respond?
Well, just to make it clear that the Deer Harbor Planning Review Committee voted in favor of a stop sign and not doing a big curve. And the locals who lived right in the area around the bridge met with Rick, and they all voted in the majority to try and keep it a small footprint and not have the big curve. So the local community had one idea, and then the county went and did something else, so, and that's how it went.